it is, filed by the state of Texas and their attorney general. The state of Texas versus the Commonwealth of Pennsylvania, the state of Georgia, the state of Michigan, and the state of Wisconsin. This lawsuit, again, at the filing at the U.S. Supreme Court, focuses in on really three main counts. The Electors Clause being violated because the Electors Clause says that it's state legislators, the legislatures, that have to make rules on the elections and changes to the election rules. There's a equal protection claim as well as a due process claim. And it closes with saying the prayer for relief is to declare that these states cannot set the current electors, and that that the legislature has to, in each of these states, appoint new electors. So this has been filed at the U.S. Supreme Court this morning by the state of Texas against the Commonwealth of Pennsylvania, Georgia, Michigan, and Wisconsin.
Texas, and then just a snowballing effect of states joining Texas. That's got to hold weight with the Supreme Court, correct?
Well, I can already report now the Supreme Court has put on the docket that the parties, so there's 4 states named here, Georgia, Wisconsin, Pennsylvania. When you look at the states that were named, they have to now respond by Thursday at 3 p.m. to this bill of complaint. And they have to respond to very specific items. So the Supreme Court is not just considering what Texas filed today. They are now going the next step, which is saying we want a response from the states named. We want a response from Pennsylvania, from Wisconsin, from Georgia. So again, I think it's very clear that, and this is the case we've been talking about to reach SCOTUS. This is the outcome determinative case. 62 electoral college votes at stake, enough to change the outcome of the election.
What is key? Outcome determinative. Because if the Supreme Court were to agree with Texas, it could ultimately be outcome determinative if the state legislatures had to pick new electors.
Right. What is at stake here? And this is why I think of all the cases, this is the most significant case. To be clear, I mean, there's no doubt about it. This is the most significant of the cases filed, and it's the most significant because it is, as Jordan just said, completely outcome determinative. What does that mean? It means that if the court were to rule in favor of Texas, those 4 states, the states named in the complaint, would in fact have their state legislatures determine the outcome. They would pick the electors. It's a very significant piece of legislation. Of all the cases all over the country, in my mind, Andy, this is the one.
There's no doubt about it, Jay, because this case now invokes the original jurisdiction of the Supreme Court, which means states can sue states for violations of law or claims that they have in the Supreme Court of the United States. The Supreme Court does not have to accept the case. It's discretionary. It depends on what 4 justices decide to do. But there is no more important case pending that has been filed all over the country than this case.
It's interesting because it raises, equal protection. It raises the usual, I would say, the significant constitutional issues.
Absolutely, including Article 2, Section 1. Basically, the state is entitled to select electors pursuant to statutory rules set by the state legislature. And in all of these states, we have elections that are at variance with their own statutory rules. That's number one. But number 2, in Pennsylvania in particular, the Secretary of State made an affirmative representation to the United States Supreme Court suggesting that ballots would be segregated that were challenged. She failed to comply.
Alabama, Louisiana, South Dakota, Tennessee, Kentucky, Florida, and I can't remember, there was 1 or 2 other states, have now all joined into this lawsuit. So you now have 8 states suing 4 states. The best case scenario, the absolute amazing, we've won, it's over scenario, would be for the Supreme Court justices to decide, was the Equal Protection Clause violated and was due process violated in this election? Now that should be, as I've said previously, a 9-0 decision, because clearly that's what happened. You have people putting pizza boxes up over the windows. You have people intimidating poll watchers. You have people throwing out poll watchers, okay? The minute these poll watchers who signed affidavits under penalty of perjury said that they were not allowed their constitutional right to witness the vote count, that right then and there becomes unconstitutional. And the Supreme Court, if they are truly originalist, constitutionalist judges that believe in our U.S. Constitution, then they should vote 9-0. Now